before a court. And we say this is the law. The important part to determine is what is the ratio decidendi of the judgment and what is merely obiter. And these are two important concepts, and I think we should deal with this. The ratio of a judgment, first of all, cannot be culled out by reading one line. You have to read the judgment as a whole. You have to see what was the issue involved and whether the observations that you are relying upon were relevant for deciding the issue at hand. If the observations that you are relying upon were not necessary to be made but have been made in the passing by the court, to decide the issue at hand, it is only obiter. Now, what is the law on ratio versus obiter? The law on ratio versus obiter is the ratio decidendi of a court is binding. But the obiter, though not binding, is also persuasive value. So it's not as if you can't rely on an obiter. You can rely on an obiter. And assessing authorities oftentimes say that this is obiter, therefore we will not follow it. No, it can't be said. Another very important principle in ratio versus obiter is, and many people don't know this, that as far as the Supreme Court is concerned, the obiter of the Supreme Court is also binding. High Court obiter can be of persuasive value, but obiter of the Supreme Court is binding. Therefore, if we are faced with situations with assessing authorities, which is saying that this is merely obiter, and it's a Supreme Court judgment that they are talking about, they are contravening the law by saying it is obiter and I will not follow it. Another very important principle, and I don't know how much time I have. I think if I keep on talking, I can talk on this the whole day. Please give me a cue when I have to stop.
Entirely for that.
Yeah, no, please stop me where it's necessary. Very important principle of law of precedence is stare decisis. What is stare decisis? Stare decisis is a principle which says, again, it is meant to secure continuity in law. Judgments which have held over time and have been followed by authorities and courts should ordinarily not be disturbed. Principle of stare decisis, which unfortunately the Supreme Court also forgot about while overruling the entry tax position on compensatory taxes. After 55 to 60 years, where this whole theory of compensatory taxes had been laid down, for I don't know how much chaos this has created, how much liability has arisen. Today, on substantive liabilities, people have paid up. They are still fighting on interests and penalties. If the principle of stare decisis was followed, the Supreme Court should have refused to go into the question of the validity of the whole concept of compensatory taxes. Two principles which are exceptions to the principle of, three principles I would say, which are contrary to or which are exceptions to the principle of stare decisis. One, where the court feels that a judgment is required to be reconsidered or overruled. One, what are those circumstances that the court should follow? And this gives us the right. Supposing there is a judgment which is staring us in the face and it is against the SSC, when should we argue that that judgment should be overruled? It's manifestly arbitrary, directly contrary to statutory law, in public interest. These are some of these issues that you should raise, not because two views are possible. Oftentimes courts will refuse to look at or refer the matter to a larger bench if it is only a second view which is possible. because then the stare decisis principle will apply. So if these kind of grounds exist, you can actually request the court to look at the whole issue again. Two other exceptions are important. Per incurium. What does per incurium mean? Incurium comes from a Latin word, incuria. Incuria means carelessness. Incuria means carelessness. It gives rise to the legal principle to say that if a decision has been rendered in ignorance of, that is how incurium, in ignorance of statutory law or a binding judgment, then the decision is per incurium. How does one apply this principle? Can I stand up before a tribunal and argue that a Supreme Court decision is per incurium? Answer is yes. Answer is yes. In fact, there used to be Justice Abhichandani, who was the president of the SESTAT. I was arguing a matter before him, it must have been 15 years back. And I raised the principle of per incurium, and there was the departmental representatives were up in arms. Sir, this is a judgment in my favor by the Supreme Court. Justice Abhichandani is, and he was a very judicious person, difficult to argue before, but very, very judicious. Justice Abhichandani said, sir, the principle of per incurium is that even a chaprasi can say Supreme Court is wrong. But then you have to justify it. It's not because you feel the Supreme Court has decided the matter incorrectly. You must refer to a provision or a binding judgment which the court was not conscious of while passing its judgment. That's one principle. So per incurium, unfortunately per incurium is applied by assessing authorities usually, or lower appellate authorities, without understanding the clear nature of per incurium. The second exception is the principle of sub silentio. The principle of sub silentio is not the principle of per incurium. It's slightly different. The sub silentio principle is that a certain issue was not in the consciousness of the court, or they were not called upon, or they did not consider it appropriate to get into that issue. They may not have ignored binding law or binding statute, but having not considered the issue, the decision is passed sub silentio. Again, that makes a decision not binding on the issue that you are arguing. Because we know that then as a legal principle again, a decision is a precedent on what it decides and not what it is presumed to have been decided. Very salutary legal principle again. A decision is binding on what it actually decides and not what it is presumed to have decided. You cannot assume that the court was conscious of a particular principle or an issue if it has not explicitly so decided it. Different from per incurium. So this is again an exception to the law of precedence, when precedence should not be followed. My iPad is getting off saying that you're talking too much. The third important, I think, issue which arises in tax law, and there's a lot of misconception on this, is on the application of the principles of res judicata. We've heard practically every assessing authority parrot this to say, no res judicata applies. Deduction apply हो गया 22-23 में, 23-24 में मैं नहीं दूंगा आपको. No res judicata applies. Straight answer to this is, res judicata may not strictly apply, and there is a reason why res judicata does not apply in tax matters, because courts have said that every assessment year or every new period offers you a new cause of action. That's the reason why res judicata does not apply. But while res judicata does not apply, the principle of consistency, CIT versus Radhaswamy Satsang, followed in 1000 cases, applies. And the Supreme Court reiterated this in BSNL's case, 2006, 3 SCC, page 1. यही citation याद है और उसके आगे कुछ नहीं. Supreme Court in 2006, 3 SCC, page 1, reiterates Radhaswamy Satsang and says inter-party decisions are binding. And it relies on a constitution bench in, I think, Amalgamated Coalfields, and says that the only exception to the principle of consistency is if you find a new fact or a new ground not decided earlier, you can depart. Recently, in this whole intermediary, line of cases on export of services, we applied, Sandeep was also involved in that case with me, in Genpact's case where Justice Dhindsa applied Radhaswamy Satsang and said that you have decided a particular claim in the service tax regime. Board has come out to say that the service tax regime and the GST regime is the same. Definitions are the same. In their own case, you have not appealed against the refunds. You have a right of appeal. In income tax, you don't have a right of appeal, you only have a 263. In indirect tax, the department also has a right of appeal. You allow a particular position to become final. You can't turn around without showing that there is any change in facts and law. You cannot turn around and say that I will take a different view. So the whole concept that res judicata does not apply, therefore I can take any view I want in a subsequent period, is absolutely wrong. Your own decision becomes a precedent against you. So a very important part of tax jurisprudence. Next issue which we deal with while dealing with assessing authorities, I will not follow this because department is in appeal against a particular decision. Absolutely bullshit. Just because there is an appeal does not mean that the precedent loses its value or sanctity. Even if there is a stay, Supreme Court says, even if there is a, Chamundi Motors is the case, even if there is a stay against a judgment, the ratio does not get suspended. It can be followed. All that happens when there is a stay is that the operative portion of the judgment, inter partes, does not operate. In this situation, we all know about this judgment, Kamalakshi Finance. Supreme Court came down heavily and passed strictures against departmental authorities, which said that there is a particular judgment and the authority says in a subsequent case to say that it is not acceptable to us because we are in appeal. Supreme Court said that we find this phrase not acceptable in relation to a binding judgment objectionable. So the SG or the ASG who was appearing with folded hands told the Supreme Court that High Court has given strictures against my officers. Please expunge them. Supreme Court says High Court has given the strictures correctly. We will go one step further and tell your officers that they have to follow the judgments of courts. And this language to say that it's not acceptable to us, we deprecate.
That was only tribunal judgment also.
Correct.
Not only high court, not of high
correct. Even tribunal judgments. Even tribunal judgments.
There is a High Court judgment of Andhra Pradesh way back in 1987.
That is in different context.
In the case of contempt of court case.
I'm coming to that. In case judicial precedents are not followed, what is the remedy? Can you file contempt? Should you file contempt? Or should the courts take it seriously? I've already spoken about East India Commercial. Supreme Court in 13 ELT, 1962 judgment, has said that a writ of certiorari lies. There are two Delhi High Court judgments, one called Spirotech and one I've forgotten. Justice Muralidhar's judgment, which said that when the department fails to follow jurisdictional High Court judgments, we will not relegate people to alternative remedy. we will ensure that the law of the state is followed. And it's not in contempt jurisdiction. Straight away a writ was filed, entertained, and the court said, this is what we have held, you have refused to follow it, writ allowed. Gujarat High Court, apart from the Andhra Pradesh High Court, which may have slipped my mind, Gujarat High Court in E.I. DuPont's case said that this is a case for contempt. We are restraining ourselves right now, Justice Padiwala, no, this was before the time of Justice Padiwala. We are restraining ourselves from issuing contempt, but we warn the department that if they do not follow judgments unreservedly, next step will be contempt. They allowed the writ, granted the relief. So it does offer us remedies in law when judgments are not followed. Question is, another facet of the law of precedents, what happens in a situation where there is a judgment and there is a circular? Circular in favor, judgment has come against the SSC. Earlier law was that the SSC can still rely on the circular. But come Dhiren Chemicals, 5-judge bench of the Supreme Court said, of course Dhiren Chemicals, they took a contrary view. When Dhiren Chemicals went back to 3 judges for implementing the decision of the Constitution bench, issue arose, what happens in the situation where now the court judgment is contrary to the circular. Court said once the court judgment has come, judgment has to be followed. Department started reopening all cases where circular had been relied upon. Comes another Supreme Court judgment clarifying it to say, in Kalyani packaging, to say, you cannot reopen proceedings on the basis of Supreme Court judgment. In fact, there's a very interesting line of cases which we used in several rates, where it says that Supreme Court judgment has come, can you issue reassessment notices on the basis of that? Simplex Concrete Piles is one short judgment of the Supreme Court which says you cannot issue reassessment notices on the basis, even on the basis of a Supreme Court judgment, subsequent Supreme Court judgment. Court went one step further to say you cannot even issue a rectification notice under section 154, that's MEPCO, Justice Kavadia's judgment. You cannot even, it does not even become an error apparent from record just because there is a Supreme Court judgment subsequently which takes a different view. These are all, again, facets of the principle of stare decisis. To say that continuity of law, finality of proceedings should not be disturbed even if there is a Supreme Court judgment subsequently. Now, we have seen in indirect taxes, there is a procedure called call book. एक डिसीजन डिपार्टमेंट के अगेंस्ट चला गया, वो अपील में चले गए, तो आपको बेनिफिट नहीं मिलेगा, आप 15 साल रुकते रहिए जब तक सुप्रीम कोर्ट डिसीजन डिसाइड नहीं करता. Gujarat High Court in Siddhivinayak, of course, has said this whole procedure is bad. Today we have a string of cases. I can tell you, at least I have appeared in 20, and there must be at least 500 cases throughout the country where department had put the matter in call book because they had gone in appeal against a decision which was adverse to them. Supreme Court, High Courts have started saying that you have not decided the matter in reasonable time. On that short ground alone, we are going to quash the proceedings. Despite the fact that you put it in the call book. Ultimately, you can't decide a matter 15 years, 20 years later. So again, a facet of presidential law, and what should be the remedy in case judgments in your favor are not being implemented. Of course, in call book procedure, there are many grounds that one can take. I was not informed when the matter was transferred to call book. There was no periodic review of that. There was no reason for putting it to the call book. I have lost all the records. Several things can be said. And on all of these grounds, courts have taken decisions in favor. Now, the last issue is what happens in a situation where there is only one High Court judgment, non-jurisdictional. Supreme Court in Kusum and God says that is a precedent throughout the country. If there is, especially in the case where it's a central law. If it's a central law, even in before other high courts, of course, it has a persuasive value, but before all other authorities, it is binding law. So this whole concept to say that because it is not jurisdictional, I will not follow it, at least as far as the authorities and tribunals are concerned, is wrong. These are some important facets which I thought on the law of precedents we must bring to the table for the benefit of the audience here. That ends my, I hope I have not taken extra time. The rest of it we'll handle in the question answer series. Thank you so much.